Hello everyone, welcome back to the video updates. It's Shade. Today's video is going to cover joint venture agreements, and I wanted to just go over the main terms that you should keep in mind when you're entering into one, or if somebody offers you to enter into a joint venture with them. And of course, people also talk about partnership or partnering up, and I would just say this particular video is about joint ventures because they're very different from partnerships as far as in the eyes of the law. And the main difference there is that the partnership agreements are agreements to enter into a relationship that's more long-term, as opposed to a joint venture where you're entering into an agreement for a particular project or a couple of projects. So those ones don't involve you running a business together. They involve you combining your efforts and your resources for a particular project, and it's only limited to that. You're not liable for anybody's operations in their business, and they're not liable for yours. So that's why the joint ventures are preferred, in my opinion, rather than entering into partnership agreements. So try to use joint ventures whenever you can, whenever it's appropriate, and get consultation from a lawyer, of course, before you sign anything, to make sure that your interests are protected. So this video is just giving you an overview for educational purposes, as always. So what are the things that you want to keep in mind when entering into one of these joint ventures? A lot of people enter into them, of course, to do real estate deals that they might not otherwise be able to pull off on their own because they don't have 100% of the funds available to be able to do it, or they don't have the know-how or the experience that the other party has. Sometimes you have joint venture agreements with two parties, sometimes you have with several parties. And in this video, we're talking about the joint venture agreements primarily for real estate investments. But of course, you can use them for different types of deals or projects in real life. So with the real estate investments, people sometimes know that they're going to buy a particular property, and sometimes they haven't yet identified the property that they're going to purchase. In the situation where you already know the properties that you are going to be purchasing, you should certainly identify them inside your joint venture agreement and consider them as your portfolio, for purposes of your joint venture agreement. And then the other thing that you want to put inside the agreement, of course, is the actual identities of the joint venturers. Are you going to be a joint venturer in your personal capacity, in your individual capacity, or are you using a business structure to enter into that kind of an agreement? And most people will use a business to do it, just to keep it all separate. Once you identify the joint venturers, then you also want to know their capital contributions, their initial contributions to the effort or to the investment. So how much are you contributing, and how much are the other joint venturers contributing money-wise? And also, does that correspond to your percentage ownership interests at all? Or does one particular party purchase the properties and have ownership interest, and then the other parties just contribute to the operating expenses? So you have to determine that up front. I always suggest that you have ownership interest in the actual properties as well, because that gives you more control, and it gives you the ability to have a say-so whenever the property is going to be sold or disposed of in any way. So you want ownership interest if I'm representing you, but you could do it however you like, depending on what kind of contributions you'll be making. And then ownership interest, of course, comes with other things as well, because you do have responsibilities for the taxes and things like that if you're part owner. So some people will have the joint venture agreements where one party is the owner of the property and the other parties only have interest in the income that that property produces, such as rental income, or interest in the proceeds once the property is then eventually sold. The thing that I find most often is that people don't understand the difference between those two things. They think they have ownership interest in the actual property when they don't. So that's why you need somebody to review the contract for you, just in case, a set of eyes that's especially trained to do that kind of stuff. So maybe a lawyer. The other important term that needs to go in there is the exit strategy. I just mentioned that sometimes people have interest in income that is produced by the property, and sometimes they have interest in the property itself. You want both if you want the best scenario, or if you have enough of a stake in this project or this investment. You do want to have ownership interest, as well as to be able to get a share of the income that it produces. So you will have to have an exit plan or a purpose also for forming the joint venture in the first place. The primary purpose will be to acquire the property, but you also have to have a plan to exit the joint venture at some point. So I think that should also be inside your agreement to say, we are going to have this property held as part of our portfolio for X amount of years, and then after those years we'll determine whether we want to sell, or we will definitely sell and split the proceeds. So that's what's called an exit strategy that you want to also have inside your document, so that there's no confusion or drawn out dispute in the future if one party wants to sell and the other parties don't want to. It's already in writing inside your original joint venture agreement how things are supposed to be handled. If there is rental income involved, you would also specify how the shares would go. So typically people get shares according to their percentage contribution. Let's say I only contributed 30% to that joint venture whenever you started the whole project, maybe towards the purchase price of the property, maybe towards the construction costs or renovations and things like that. And my percentage contribution was 30%. Then most likely I only get 30% of rental income that comes from that property. If your contribution was 50%, then you get 50% of all the rental income that comes from that property. And then the other party that has the 20% remaining will get the remaining 20%. So that's typically how people share the income that's produced from the property. And they also tend to share the profit in those same ratios, as far as the ratios of contribution typically also mirror the profit sharing ratio. And so that means that you do have to specify for each category. You cannot just leave it open and assume that it's self-explanatory. Inside the document, you have to specify the profit sharing ratios in a separate paragraph or provision, even though it mirrors your initial contribution ratios. And then you also have to specify it again if you're talking about income that's being produced from the property. The other thing that you want to also cover will be what will be considered operating expenses, or any kind of expenses that will be deducted from the original contributions, or will be deducted at the time that the property is eventually sold, before you will determine the profit margin. So essentially you have to figure out what is profit, what are the costs that are deducted first before the profit is determined. And typically you deduct all the costs that are associated with acquiring the property, with remodeling or renovating the property, and also with maintaining the property, like the property taxes and any kind of utilities and stuff like that that needs to be paid. That should come off the top whenever you end up selling the property, and then the remainder that's left is split according to your profit sharing ratios. You can do it however you like, but that's typically how it works. And so you do want to specify, no matter what it is that you agree to, as long as it's in writing, that's what's most important. So make sure you understand fully how the profit will be defined, what are the deductions that are acceptable to be taken out of the top of the sale price before the profit is then split amongst the joint venturers. So that's something you have to fully understand. You can't just leave it as, okay, I'm in a joint venture and I'm only giving them $20,000. You do want to know what your $20,000 is going to do. Are you getting the $20,000 back from the top if everything goes according to plan and the property appreciates in value? Would you get your $20,000 out first from the sale price? And then would you then be able to split whatever profit is remaining after all the costs are deducted? That's very important to know. And of course, sometimes things don't go according to plan and there's a loss instead of a profit. And so how will the loss be handled? That is a term that's also pretty much covered the same way that the profits will be handled. So if I contributed 30% to the project, then most likely I also would absorb 30% of the losses. So that's typical, but you can always negotiate anything you like. The other things that could come up in the context of a joint venture agreement is that one party brings money and the other party actually brings labor and expertise, as well as, time, effort, things like that. So the party that's bringing labor and expertise is typically a contractor or builder, and that party may not necessarily contribute money to the project, but they also have a percentage share in the profits. So you'll have to determine how you value the labor and all of the effort and expertise that the other party is bringing. What is the value of that? And so what kind of percentage is fair to give to that person or that company based on this type of arrangement? Are they going to be part owner of the property? In that case, I don't like for the builders to be part owner, because they're not putting money forward for the initial purchase of the property. It makes more sense that they just have a percentage interest in the profit that you make at the very end, but that they're also allowed to deduct their expenses from the top of the purchase price before you determine the profits. So again, some people bring money and some people sometimes have no money to bring, but they do have contractors, subcontractors that they can bring. They have friends that are willing to help to build without getting paid yet, and then they can get paid at the end of the project once you have your exit plan executed. So your exit plan in that case would be selling the property most likely, and so the contractor would get paid at that point for all the costs that the contractor incurred. But also if there's profit left over, then the contractor has a chance to split the profit with you. So you would have that kind of set up, but your exhibits have to be there to give you an estimate of what those kinds of costs would look like. You don't want a builder telling you verbally that they are able to build something similar for $100,000 and then at the end of the project give you a bill for $200,000. So you want it to be fair. You want things to be a little bit predictable. You want things to be very predictable. They're not always 100% predictable, but you can at least have some guidelines inside your agreement that says any amounts over X dollars should be approved by all the joint venturers. So you have to have bids that the contractor would provide in such a situation, and the contractor would have to have those bids approved by all the joint venturers before being able to continue with the work. Of course, besides the labor, there'll be materials costs as well. You have to determine who pays what. And maybe the contractor will be able to provide the materials, maybe not. If they're not able to, then of course you'll decide how the material costs will be handled and who will be paying those. The other thing that people tend to leave out is the release of lien, the unconditional release of lien that the contractor would give you at the end of the project. And that's, of course, going to help when you're trying to sell the property so that there's nothing hanging out there. Also, I like to have the language in there that there's unconditional release of lien once the contractor has been paid off according to the terms of the joint venture agreement. So you should be able to obtain that at closing, for instance, or right before the closing, once the contractor sees that the settlement statement shows that the contractor will be paid according to your agreement, and then they should be able to give you a release of lien so that there's no issue in the future about somebody putting a mechanic's lien against that property. It could be the contractor or the subcontractors that worked for the contractor, but you want to make sure that you have that unconditional final release saying that everybody's been handled, everybody's been paid off that worked on that property, and you don't want any surprises in the future for you or for the person that's buying that property from you. So those are the tips that I have. There's a lot more that should be covered inside the agreement, but these are the main terms. Whether you have a reserve fund depends on how you're holding the investment property. If you're holding it and getting rental income or some other form of income from it, then it makes sense that you would have reserved funds from your contributions as joint venturers so that you can have money sitting there in case the property taxes go up, in case there is damage to the property and you need to pay a deductible and things like that. So those are the things that would depend on what kind of strategy you're using for your investment properties. I hope this video has been helpful to you. Again, you do want to do a joint venture agreement when it's just one or two projects that you're working on. You don't want to be liable for the other person's business practices, and they don't want to be liable for yours. So your distinct entities just coming together for the purpose of this particular project or a couple of projects. And that's what a joint venture really is for. And it's really the preferred form of partnering up, for lack of a better term. Partnership agreements are more involved and they do expose you to more liability overall. So as always, if you have questions about anything that you're looking at, always get a consultation before you sign on the dotted lines, especially if there's a significant amount of money involved. And typically with real estate, there's a significant amount of money involved. And the other thing that I wanted to say that I forgot to mention is that I do get situations where one joint venturer goes MIA, missing in action, and the other joint venturers are left not being able to execute that exit strategy because all 3 or 4 were supposed to sign off to be able to sell the property. Well, in order to protect yourselves, to make sure that somebody is not assigning rights without your permission and assigning the ownership interests and things like that, even if you're not specified as having ownership interest, but as having only profit sharing interest in that project, you do want to file a memorandum of contract into the property records where that property is. You will file the memorandum of contract to warn other people that you have some sort of interest in that property. And so that helps you to know if one joint venturer is trying to sell off the property without involving the others and without telling you. So that kind of tool is very useful just to alert third parties to the fact that you might have some sort of interest in that property, and then they have to contact you to find out more information. But you do not have to file your joint venture agreement into the property records, just a memorandum of contract, okay? That is the last thing that I wanted to mention. So hopefully this video has been helpful to you. If you want to hear specific topics, make sure to let us know what you want to hear, and we'll cover that as well. Thanks for watching as always, and take care.